page, facebook.com/booktv.
All right. Well, I am J.C. Chris Hall, and KrisAnne is my wife. Many of you here already know KrisAnne, and I don't know how many visitors we have that don't, but KrisAnne is a native of St. Louis, Missouri. She got her bachelor's degree in biology and chemistry from Blackburn College in Illinois. Joined the United States Army, was trained as a Russian linguist for military intelligence in the Army. And as most people know here, she worked for the state attorney's office for many years as a prosecutor after graduating from the University of Florida, Levin College of Law. And she worked under Jerry Blair in the state attorney's office, then went to work at a constitutional law firm defending religious and First Amendment liberty for several years. Came back again to the state attorney's office and worked under the Honorable Skip Jarvis, and was providentially launched from there into speaking about our liberties and the Constitution. She now travels and teaches an average of 265 events in over 22 states for about the last 6 years since that providential launching. She has a radio show in addition to all of that she does 6 days a week. One of those is broadcast as a television show on the Christian television network Lifestyle Channel. And many more things. She's been a plumber, an EMT, a biochemist, a paralegal, an attorney. I think the labels that she carries most proudly would be mother, wife, Christian, and patriot. The slogan on her radio show is liberty over security, principle over party, and truth over your favorite personality. She takes a lot of flack because she happens to be of the belief that we should protect, defend, and abide by constitutional principles no matter who's in office or which party is in power. Please welcome KrisAnne Hall.
All right, here we go. Can you hear me now? Yes. Okay, I'm very excited to be here. It's always just warming to my heart to be at home. You can imagine teaching 265 events in 22 states every year. We don't see our home very often. But we are blessed nonetheless, and we are happy to be here. Right now, there is a 77-year-old man, a veteran who served our country, in federal prison right now in Colorado because he built a stock pond on his land with the permission of his state, with the direction of the Army Corps of Engineers, but the EPA said we don't care, and prosecuted him for violating the Clean Air Act. Prosecuted him for violating the Clean Air Act, even though the Clean Air Act has a section that exempts stock ponds from their jurisdiction. We have an Amish farmer in federal prison because he made a salve out of chickweed and shared it with his friends and family members. We have a disabled U.S. veteran who's had his civil rights stripped from him by a federal judge for following state law. We have farmers, dairy farmers in Indiana, being harassed for having raw milk and cheese. We have political prisoners in Oregon and Utah or Nevada because they took the bold and audacious step of peacefully protesting federal government overreach into their land and into their property. So let me ask you a question. Do you think our federal government is still out of control? Yeah. We need to find the solution, do we not? Yeah. As I travel and I teach, it is almost unanimous, the response I get when I ask, do you think the federal government's still out of control? And I teach varying groups with different ideologies, different political spectrums, and for different reasons, everybody has an idea that the federal government is out of control. And then the most asked question I get as we teach, what do you suppose that is? What do we do about it? But if we've been teaching the Constitution properly for the last 150 years, we would know what to do. We don't have to reinvent the wheel. We don't have to find the solutions. Because the same solutions that existed in 1789 when we ratified the Constitution are the same solutions that exist today. How do we get the federal government under control? The solution is the states must fulfill their obligation as a proper check and balance. Look at what Thomas Jefferson says. If the states look with apathy on this silent descent of their government into the gulf which is to swallow all, he's talking about Washington, D.C. When he's talking about this gulf which is to swallow all, he's talking about everything being consolidated from big to little in Washington, D.C. Your environment being controlled by Washington, D.C. Your right to keep and bear arms, your land, your food, your medicine, everything being controlled by Washington, D.C. has become the gulf which is to swallow all. And look what he says. We have only to weep over the human character formed uncontrollable, but by a rod of iron. When the government is out of control, the society is reduced to chaos. When the checks and balances are not functioning, then the only thing that can control chaos is a rod of iron. Our framers gave us the greatest gift, the opportunity to self-govern. And our greatest condemnation today is our refusal to self-govern. Everything is in place. We just simply must be dedicated to exercising our checks and balances. How does the state have the right to check the federal government? Well, that's what we're going to go through today. This whole class is going to be establishing, not by my opinion, not by my interpretation, but by history, by fact, and by the words of the men who created our constitutional republic. See, I don't really feel myself to be a teacher of this information today. I'm more of a facilitator, facilitating the lesson that has been before us since we ratified the Constitution. How does the state have a right to check the federal government? because the states came first. We need to reestablish some basic foundational principles. We need to connect some dots so that we start heading off in the right direction. And we need to get back to some very basic things. And when I mean basic, I mean ABCs and 1, 2, 3s. And just that simple principle of understanding that the states came first establishes a very important understanding of who's in charge. I want us to look at how first the states came, because we don't teach this history quite accurately in our schools, so I think it bears necessity to sort of reestablish the historical truth. In our textbooks, we teach that we became independent from Great Britain with the signing of the Declaration of Independence on July 4th, 1776. That's not true. We became independent from Great Britain with the ratification of the Lee Resolution on July 2nd, 1776. The Lee Resolution, a three-step process to declaring independence from Great Britain, brought forward by a delegate from the state of Virginia by the name of Richard Henry Lee. Richard Henry Lee proposes the Lee Resolution to the Continental Congress on June 7th, 1776. And on July 2nd, 1776, the Lee Resolution was brought to the Continental Congress. It was debated, voted, and ratified into law. Our independence from Great Britain was not a random act by a bunch of rogue elite slave owners who wanted to separate from their government so that they can have the power to oppress everybody. It was a legislative act by a duly elected legislative body, and just as legally binding as anything that our Congress does today that's constitutional. As a matter of fact, this was such a huge day that John Adams would write home to his wife Abigail on July 3rd and say, July 2nd will be an epic day where Americans will celebrate their independence forever. Do you know it wasn't until the mid-1800s that we started celebrating our independence on July 4th? So knowing this, that our states, not by opinion or interpretation, but by legal fact, by historical fact, became independent states on July 2nd, then we must admit that the states existed prior to everything, right? Prior to the Declaration of Independence, even by 2 days. The Declaration of Independence was not actually fully signed on July 4th. July 4th is when the Declaration of Independence was published to the general public. It had only been signed by John Hancock. It wouldn't be signed by the rest of the representatives of the states until the end of August. But now we have to understand, on July 2nd, is there a federal government? No, because we've just thrown it off. On July 4th, there is no federal government either. There is just the states. Now, our first federal government is formed through the Articles of Confederation. But there's a problem. And the problem isn't probably what you've been taught. You see, popular teaching teaches that the Articles of Confederation failed because we created a federal government too small. Do you know the implication is then, right? That the next federal government that we created was much bigger and much more powerful, and that simply is not true. When you look at the debates and you look at the history, you see that the largest driving force to the reconsiderations of the Articles of Confederation had to do with an authority that was actually delegated to the federal government. See, the problem was not that the Articles of Confederation created a federal government that was too small. They created a federal government that had insufficient guidance on how to do what they were supposed to do. So, like governments, without proper guidance and proper checks, they'll do things they're not supposed to do, which they were. But they were also doing the things they were supposed to do, but not doing them properly. For example, one of the biggest points of contention with the Articles of Confederation had to do with treaties. Treaties is a power delegated to the federal government. Only under the Articles of Confederation, the federal government was making inequitable treaties. They were making treaties with foreign governments in which one state or a set of states had to foot the whole bill. And then a completely different state or completely different set of states got all the benefit. Now, the states who were being required to pay for the expenses of the treaty were obviously in opposition. Are you kidding me? That's not why we joined this union. So we can transfer our prosperity to another state? That's not what general welfare means. And they were refusing, righteously so, refusing to comply with these treaties. Now, the states who were supposed to get all the benefit are now mad at the states who won't pay the bill. But we have an even bigger problem. Because a treaty is a contract with a foreign government. A foreign government, mind you, that has no idea how we're supposed to be working. So they have no idea that the federal government has made an unlawful treaty. All they see is they made a contract with the United States, and the United States is not holding up their end of the bargain. So we are most literally on the verge of war between the states and on the verge of war with foreign countries, and we just got started. So Congress is like, look, this is not going to work. We're going to have to pull together a new delegation. We're going to have to fix these Articles of Confederation. And the Constitutional Convention is called. Now, the Constitutional Convention does not amend the Articles of Confederation because the Articles of Confederation are not what we operate under now, right? What we operate under now is called the Constitution. And the Constitution has actually declared itself to be the more perfect union. That's why it's called the more perfect union, because it was supposed to be more perfect than the Articles of Confederation. Now, we're going to learn a little bit later that the nature of the Constitution is that it is a contractual agreement between the states. Now, you can't have two competing contracts. If you're going to have a new contract, you have to get rid of the old contract. And that's exactly what has happened. Now, when we get rid of the Articles of Confederation, what happens to the central government that it created? It's gone too, right? So right now, prior to the ratification of our current Constitution, there is no federal government. There is only the states. Now, we also know that to be true from fact and history. How many of you remember from your history class or your civics class that there was a very precarious moment prior to the ratification of our current Constitution where we did not have enough states to ratify? How many of you remember that? And the proponents of the Constitution were very concerned, and they said over and over and over again, if we do not ratify the Constitution, there will be no union. The states will be separate and independent. They will operate independently, and we will have no means to operate as a unit. Doesn't that fact pretty much tell us that there is no central government anymore? We have, over 13 years, where the only consistent government that exists without interruption is the states. 13 years. 13 years before the federal government. The states came first. In order to understand the role of the state, we must understand what is a state. What does it mean to be a state? Now, my opinion on that is irrelevant. I think the facts tell us all we need to know. And we find the definition of the word state in the last paragraph of the Declaration of Independence. A state is not a colony. Now, this last paragraph of the Declaration of Independence actually comes from the first paragraph of the Lee Resolution. And it says, "We therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people of these colonies, solemnly publish and declare." See, we didn't become independent on July 4th. We published and declared what we had done 2 days prior. That these united colonies are, and of right, ought to be free. See, we've just discovered what we are not. A state is not a colony. There must be a distinction, right? Because if there is no distinction between a colony and a state, then there's no point in even making that statement. It's a redundancy. So what is the difference between a colony and a state? Well, very simply, a colony is not free and independent. If you live in a colony, you must seek permission and guidance from the central government before you can use your land. You must seek permission and guidance from the central government before you can use or manage your resources. You must seek permission and guidance from the central government before you can create some laws, before you can regulate your businesses, even before you can educate your people, if you are a colony. Anybody feeling a little bit like a colony out there? Well, here's the good news. We are not colonies. We are free and independent states. Knowing what a state is not as good as knowing what it is. So here we know it is not a colony. So what is it? Continuing now with the Declaration of Independence, we know that these free and independent states, are absolved from all allegiance to the British Crown, and that all political connection between them and the what? State of what? State of Great Britain. You see, that word state is not simply synonymous with New Hampshire, Rhode Island, or Virginia. That word state is synonymous with Great Britain, France, and Germany. We made 13 free and independent sovereign governments. Now that's beautiful, isn't it? That's a great explanation. But we can go even further, because the Declaration of Independence not only tells us what the state is, but tells us the power that each and every state holds. The people, through the authority of the people, have delegated this power to each free and independent state. They have full power to levy war, conclude peace, contract alliances, and do all other acts and things which independent states, like Great Britain, France, or Germany, may of right do. And this is the power your state holds today. Now, someone might try to explain this away and simply say, well, if your state is not one of the first 13, then this does not apply to you. Problem is, that's not historically accurate. That is not politically accurate. That's not legally accurate or constitutionally accurate. There is a doctrine called the equal footing doctrine, which says that every state that enters the Union enters on the same footing as the first 13. And there's your footprint. full power to levy war, conclude peace, contract alliances, establish commerce, and do all things that each and every sovereign and independent government on the planet has the right to do. Someone might try to say, well, that may be who you were when you formed the state, but when you entered the Union, you surrendered your power. That's ridiculous. But it's also historically inaccurate, legally inaccurate, politically inaccurate, and constitutionally inaccurate. What does the Constitution say about power? The 10th Amendment says the power's not delegated. It doesn't say the power's not surrendered, it says the power's not delegated. Now let me ask you a question. Are the words delegate and surrender synonymous? Absolutely not. Give yourselves a hand. You now know more than the Supreme Court of the United States. I have actually read Supreme Court opinions written by Justice Antonin Scalia that declares that the states surrendered power. And that's simply not what happened. Let me ask you a question. How many of you have ever heard of a sovereign government by the name of Germany? Some of you don't know Germany. Okay. Didn't Germany join the European Union? All right, so let's all fly over to Germany. We'll hold a big town hall meeting, and we'll explain to the German people and their chancellor that because they joined the EU, Germany is no longer a sovereign government. How do you think the Germans are going to take that little piece of news? So why do Floridians? Our states were created with a greater sovereignty than Germany could ever imagine. Our states were created under the principle that we hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain inalienable rights. Germany was created under the principle that kings delegate rights. We were created with a greater sovereignty, and yet somehow we accept a greater servitude. What is the nature of this Constitution that we are trying to operate, trying to apply properly? Well, the Constitution, legally speaking, is a compact. It is a legally binding compact. It is a compact is an agreement between legally sovereign governments. That's how you distinguish a compact from a contract. A contract is an agreement between legally sovereign people. And when I say legally sovereign, I mean you've achieved the age of legal consent. Can your 15-year-old create a legally binding contract? No, because your 15-year-old is not sovereign in the eyes of the law. He's still subject to his parents. But a compact is what our Constitution is. We know that because that's what the drafters of the Constitution call it. And a compact is an agreement between legally sovereign states. What's the structure of the compact? How does it work? The states are the parties to the compact. Let's think about this. The compact is a legally binding agreement between sovereign governments. Going back to what we've already learned, connecting our dots, what were the only legally sovereign governments that existed prior to the ratification of our Constitution? The states. Since we know that the states, that the Constitution is a compact, and a compact is an agreement between legally sovereign governments, then we must admit that the states are the parties to that compact, because they're the only ones that existed. The states, then, we must know that the central government is the product of the compact. Did the federal government exist prior to the ratification of the Constitution? No, the federal government existed once the Constitution became a legally binding contract. Now, someone might try to tell you that I'm bending or misapplying the truth, and that the Constitution is an agreement between the people and the federal government. That is not true. And you can prove that false with one simple fact. Was the Constitution ratified by popular vote of the people? No. How was the Constitution ratified? Through the states, the representatives of the people, but through their states. Someone might try to tell you that the Constitution is an agreement between the states and the federal government. There are people that I endearingly refer to in our society today as federal supremacists. These are people that try to explain that the federal government is superior to the states in all cases, or in the very least is co-equal with the states. And that co-equal position they will try to support by saying that the Constitution is an agreement between the states and the federal government. That is a temporal impossibility. Because you see, the central government is the product of the contract. You cannot be a party to the contract if you are the product of the contract. You cannot sign the contract into legal being if you do not exist until the contract is signed. And the only sovereign governments that existed who could be the parties of the compact are the states. The central government is the product. Knowing that the states are the parties and the central government is the product, then we must know that the states are the creators of the central government, right? If the states created the Constitution, which created the central government, then the states created the central government. And when they created the central government, they created a limited central government. They enumerated its specific powers, and then they did the most important thing they could have ever done. They reserved all other powers to themselves. The powers not delegated to the United States are reserved to the states and to the people, respectively. Now we need to ask, what power is delegated? Because if we're going to keep the federal government in its designated power structure as required by the Constitution, then we have to know what power has been delegated. I think we also need to know what is delegated. What does that term mean? Let's look at this. We don't have to have the Supreme Court give us their ultimate opinion on the powers delegated to the federal government. We don't have to interpret anything, because James Madison, the father of our Constitution, wrote it down. In a document that we call Federalist 45, he says the powers delegated, there's that word again. This is a very, very important word when understanding the right and the duty of the states and their power over the federal government. The powers delegated by the proposed Constitution to the federal government are few and defined. We put them in a box. He says those that remain in the states are numerous and indefinite. Now, Madison doesn't leave the definitions at that. He's going to get downright specific now. He says the former, meaning the powers delegated to the federal government, will be exercised principally on external objects. That's how our framers referred to foreign affairs. And then he names those specific powers as war, peace, negotiation, foreign commerce. He says the power to tax will come from these four delegated powers. Not education, not environment, not welfare. The power to tax was to be reserved to these war, peace, negotiation, and foreign commerce delegations. Now let me ask you, because this list of powers should look familiar to you. Didn't we just see this power resting somewhere else a few minutes ago? Where was that? With the states. Remember, the Declaration of Independence said the states possess full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states, Great Britain, France, or Germany, may have right to. Well, let's look at this. The federal government has been delegated that power. If someone has delegated war, peace, negotiation, and foreign commerce to the federal government, who has delegated that power to the federal government? The states. That's why this word is so important. Now let's look at the definition of the word delegate. Delegate. A temporary trust of responsibility or authority by a higher power to a lower power. Wow! We've just established by fact, by history, by constitution, that the states delegated power to the federal government. That means that the states are the higher power and the federal government is the lower power. Not only this is the distinction between delegate and surrender. To delegate is a temporary trust. It's like an employer with an employee. If I own a business and I hire someone and I say to them, I want you to do this job for me. What if they do the job wrong? Do I have to, as the employer, do I have to keep allowing them to do the job wrong? No. Because I never surrendered the power, I simply delegated it to my employee. And once the employee fails to operate in that authority or responsibility the way the higher power dictates, it's within the rightful authority of the higher power to pull that power from the lower power, firing them. Or in the alternative, saying, you'll do it the way we want you to do it, or you will be fired. So what power has been reserved? War, peace, negotiation, foreign commerce, foreign affairs being delegated to the federal government by the states to the federal government. What powers have been reserved? Well, guess what? We don't have to guess. We don't have to file a lawsuit and take it to the Supreme Court for them to announce to us the powers that are reserved to the states. Because James Madison, the father of the Constitution, has already told us, and through the ratification of the Constitution, the states have declared Madison to be correct. He says, continuing in Federalist 45, the powers, what? Reserved to the several states. Now that word several there doesn't mean a few, it means separate and independent. Will extend to all. What does all mean? All, right? Well, I think it sort of begs the question of clarity, right? Because we know we have a government that likes to redefine the meaning of the word is. So as long as we're all in agreement, all still means all, extends to all the objects in which objects which in the ordinary course of affairs, all the objects in the ordinary course of affairs concerns the lives, liberties, properties of the people, the internal order, improvement, and prosperity of the state. What about the EPA and the FDA and the Bureau of Land Management? Oops. Property of the people, right? What about the Department of Education, HHS, USDA, the FDA? Lives of the people. What about the FBI, the DHS, the FCC, the SEC, the FAA, the ATF, the Department of Energy? I mean, the list grows, right? What are those things? The internal order, improvement, and prosperity of the state, the lives of the people, the properties of the people. And the father of the Constitution says these are not powers delegated to the federal government. They are powers reserved to the states. Why is power reserved? So that the states can retain the integrity of the Constitution and maintain the federal government in its limited and its few and defined authorities. Look at this. In 1830, we were experiencing many of the things that we're experiencing today. A federal government coming outside of its few and defined box, states trying to push it back in. Some people are thinking that the federal government should do these things. Some people thinking that the federal government should not do these things. It's a period of history called the Great Debate of 1830. And in this great debate, John Calhoun is going to try to help us understand the power of the word reserved. He says, the doctrine which denies to the states the right of protecting their reserved powers. Now that's a pretty bold statement, declaring that the states have a right to do something. Why would they have a right to protect their reserved powers? Because they're reserved. Let's look at the word reserved. It means to exercise dominion over a thing to the exclusion of all others. Think about this. If there is a chair on this stage, and on that chair is a sign that says reserved to KrisAnne Hall. If someone else sits in that chair, what do I have the right to do? Kick them out, right? If the chair says reserved to KrisAnne Hall, and I don't have the right to kick them out, is the chair reserved? No. By establishing through form and function that the state's powers are reserved, the people in creating the states and the states in ratifying the Constitution declared that these powers are the property of the states to exercise dominion over that property to the exclusion of everybody else, to include the federal government. Now there's a very important consequence of denying the power of reserved. And Calhoun says, if the states do not have the right to protect their reserved powers, then what you are actually declaring is that it is the federal government who has the right to determine finally and exclusively the limit of its own power. And if the federal government can determine the limit of its own power, then what is the limit of the federal government's power? There is none. Their own will. And a government limited only by its will is not a constitutional republic. It is a totalitarian kingdom. Now let's think about this, going back and connecting our building blocks. The Constitution is what kind of document? It is a compact. And a compact is what? An agreement between sovereign governments. The Constitution is a compact between the sovereign states. But if the states must submit to everything that the federal government says, without question, are the states sovereign? No. And if the states are not sovereign, can they create a legally binding contract? No. So if the states are not sovereign, if they cannot protect their reserved property, if the federal government can dictate to the states how it operates, then the states are not sovereign. The Constitution is not a legally binding document. We are not a constitutional republic. We are 50 colonies in a federal kingdom. But here's the good news. The states are sovereign. The Constitution is a legally binding contract, and nothing has changed. The only thing that really needs to happen is we have to change the way we think about government, the way we want government to operate, and we have to change how our states operate within the republic. Because if the states simply acquiesce, then we are not a republic anymore. We are a kingdom. What happens when the federal government uses undelegated power? Thomas Jefferson explains what happens. He says, when the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Let's look at that for just a second. Because what Jefferson is saying is that when the federal government uses power outside of the Constitution, it is stealing that power from the states. How is he saying that? Well, let's look. What is your name, sir? Gary. Okay, so for this analogy, we're going to pretend I have just stolen Gary's car. Do I have the authority to drive Gary's car? No, I do not. Do I have the authority to sell Gary's car? No, I do not, because my power over Gary's car was not legally delegated. It is an undelegated power. That means any act I exercise over Gary's car is unauthoritative, void, and of no force. Because I've stolen it. I do not have legal possession of his car. Does Gary have to sue me to get his car back? No, he simply provides the title deed to the local officials, and they have to return the car to him as the rightful legal owner of that property. Jefferson is explaining to us that when the federal government uses power outside the Constitution, it is stealing power from the states because the power has been reserved to the states. It is their rightful legal property, and the federal government is using their property without proper legal delegation. Do the states have to sue the federal government to get their power back? Absolutely not. They simply have to provide the title deed to their power. What is the title deed to their power? The Constitution. Do you know the state suing the federal government to get their power back is not only unnecessary, it is ridiculous and dangerous. The states suing the federal government to get their power back is like Gary suing me to get his car back, showing up in court and finding out that the judge and the jury are all my family members. Right? Because the states are suing the federal government where? In federal court, where the judges are appointed by the federal government. That is a stacked court. And given the progression of our federal courts today, do we have any reasonable expectation that our courts will side against federal power in favor of the states and the Constitution? Not only that, it's dangerous. If the states are left with the only recourse of suing the federal government, what happens when the federal government says, nope, it's ours? Then we are either reduced to being tributary slaves to an oligarchy of 9 kings and queens, or we're left with a rod of iron. Why must the states check federal power, because it is the peaceful, rightful remedy, and it is their duty to do so. In 1799, we're experiencing similar circumstances of today, a federal government coming out of its few and defined box, the states trying to enforce the constitutional contract and keeping them in their few and defined box. And in this period of time, we have the legislators of the state of Virginia giving a General Assembly address to the people, saying, look, we have a job and a duty that's above everything else. See, the number one job description of your state and local government is not economic improvement. The number one responsibility of your state and local government is not business regulation, education, or security. The number one responsibility of your state and local government is, as these legislators in 1799 declared, to be the guardians of the state's sovereignty. Why must they guard the state's sovereignty? Because they have taken a solemn oath, I do swear I will support and defend the Constitution of the United States. Because remember, we've previously established that if the states are not sovereign and independent, they cannot make a legally binding contract. And if they cannot make a legally binding contract, then the Constitution is dissolved and the Union does not exist. There is no republic. It is the obligation of the state and local governments under their oath to maintain the sovereignty of the state. What is the greatest attack on the sovereignty of the state? Federal encroachments. Every dollar that your state and local government takes from the federal government, any dollar, $1 from the federal government to your state and local governments ends their sovereignty. Right? Because who pays the piper dictates the tune. And then the states and the local governments must operate according to the dictate of the federal government in order to keep that funding. And before long, you may have a population of people who think that they cannot even survive without federal money. The creation dictating over the creator. That's an aberration. How do we see these federal encroachments? They say these federal encroachments may come to you clothed with the pretext of necessity. Because you know we must have national health care, right? Of course we must have national health care. If we don't have national health care, we're all going to die. I got bad news for you, we're all going to die. But when the federal government is funding health care, the only thing that will be established through national health care is that the federal government will decide when, where, and how you die. They said not only will it be clothed with the pretext of necessity, they will be disguised by the arguments of expediency, because you know we have to pass the bill so we can read the bill. Sound familiar? Okay. There is nothing new under the sun. Human nature never changes. And the same tools of government, the same reactions of people existed in 1799 as existed today. And those who do not know their history are doomed to repeat its mistakes. What are the consequences of these federal encroachments? They said that they will expose us to, establish precedents of, all the consequences of usurped power. Because you see, the lion with his head out of the cage is his whole body. And when you let the lion out of the cage, you shouldn't be surprised when he bites your head off. That's why we put them in a few and defined box. What must the state do The father of our Constitution, James Madison, tells us what the state must do. In the case of deliberate, palpable, and dangerous exercise of other powers not granted, who? The states have the right to interpose. Madison says the states have a right to step in between the federal government's exercise of power to defend the rights and the liberties of the people. Why do they have the right to do that? Because the power is reserved. They have a right to keep the federal government off their power because the power has been reserved to them. But notice that Madison says they not only have a right, they are duty-bound to interpose. Can we all agree that a duty is greater than a right? Why are our states duty-bound? Because we hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain inalienable rights, and that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. There is only one reason government exists. There is only one reason the authority of the people created the free and independent states, and that was to secure our rights. And if the states are not stepping between the federal government and limiting it to its few and defined powers, then they are failing to accomplish the single purpose for their existence. And that's why they have a duty. How does a state interpose? Thomas Jefferson explains the process of interposition. When the several states who formed the Constitution, being what? Sovereign and independent, have the unquestionable right to judge of its infractions. Why? Because they're the creators of the contract. They're the parties to the contract. That a nullification by those sovereignties, who are the sovereignties? The states, is the rightful remedy. What is nullification? What is a sovereign state? A sovereign state is the right of the states to exercise their reserved powers, to protect their reserved powers. A sovereign state is not the rejection of all government and the commission of violence against government officials. Nullification is not a state refusing to comply with all federal government. Nullification is the state saying, you stole my car, and I'm not letting you drive it anymore. I'm taking the keys back, and I simply will not comply with stolen authority. That's what nullification is. Now, if we're going to be a little bit more accurate about our analogy with Gary's car, let's just assume now that Gary has gone on vacation for 3 weeks to the Bahamas. Or he's been in a coma for the last 150 years. The day Gary goes on vacation, I steal his car. Now, he doesn't know his car's stolen. He's living it up in the Bahamas. But for 3 solid weeks, I drive around in Gary's car. Everybody that sees me drive Gary's car assumes that I have the legal authority to do so. Why? Because nobody is objecting. Gary comes home from vacation, realizes that I've stolen his car. He steps up and says, "You stole my car. I am taking my car back because I have the rightful legal authority to do so." Just because the federal government has been exercising stolen power within your states for the last 100 years does not change that stolen authority into a legal authority. It is still stolen. It is still unlawful. Now, there are people, my federal supremacist friends, who assert that nullification is not a rightful remedy. And what they'll say is that nullification is not the rightful remedy because the Supreme Court is the ruler of the Constitution. I was in a federal courtroom the other day in Kansas where the federal judge announced
page.
Announced that it is the job of the Supreme Court and the circuit courts to announce the Constitution. No, I'm sorry. We announced that in 1789. But is this a proper interpretation of the authority of the Supreme Court? Can the Supreme Court determine its own authority? Because you see, that's what they've done. The Constitution does not delegate the ultimate definitive authority of the Constitution to the federal government or to the courts. It's a power they secured for themselves through a series of their own opinions. Wouldn't you like to live in that kind of universe where you could just write your own power? Look at what Madison says in 1800. If the decisions of the judiciary be raised above the authority of the sovereign parties to the Constitution. Who are the sovereign parties to the Constitution? So let's say it like that, why don't we? If the decisions of the judiciary be raised above the authority of the states, dangerous powers not delegated may not only be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Consequently, the ultimate right of the parties to the Constitution, who are? The ultimate right of the states to judge whether the compact has been violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislative. Madison is reminding us of some very important facts. Number one, the states created the Constitution. Number two, the states created the federal government. When the states created the federal government, they created three branches of federal government: the legislative, the executive, and the judiciary. That means even the judiciary, any power the judiciary exercises is power that has been what? Delegated to it by the states, which means the states are the higher power and the federal government is the judiciary, the Supreme Court is the lower power. And if the Supreme Court, being part of the whole, can define the power of the whole, then what is the limit to the whole's power? It's unlimited by only its will. Now, your federal supremacist friend will try to assert to you that Madison has changed his mind several times about nullification. Here's the problem. Every one of those examples of Madison flip-flopping is an example where Madison is talking about nullification from a different context. How many of you ever heard of the phrase, context is king? One of the examples they'll give you is this one. Madison is speaking to the House of Representatives during the ratification debates for the Bill of Rights. He is trying to assert that the Bill of Rights will be safely inserted into the Constitution because the courts will be in a unique position to guard our rights. You see, there was an argument that if we put in the Constitution a Bill of Rights, a list of rights, that the federal government would use that list against us. That someone in government, as Hamilton describes, disposed to usurp our rights, would simply allege that through the list, we've created an authority of the federal government to regulate our rights. Right? It's not on the list. Since it's not on the list, we must have wanted the federal government to regulate it. Otherwise, we'd have put it on the list of rights. And if it's on the list of rights, how do we know what it is? So we will do you a favor. We'll define these rights for you so we don't usurp or infringe or abridge upon your rights. Madison said, look, we can have a Bill of Rights, and the federal government will not abuse those rights. The legislative or executive powers will not abuse those rights because the judiciary will be an impenetrable bulwark against every assumption of power in the legislative or executive. Do you see state in that list? No. You see, the check of the judiciary is a check on the legislative and the executive, not on the power of the state. But you see, Madison doesn't end here, because his very next statement establishes what we've already established by fact and history and truth. He says, besides the security of the courts limiting the executive and the legislative branches, there is a great probability that the Bill of Rights will be enforced because the state legislators will jealously and closely watch the operations of this government. Why will our state legislators be jealously and closely watching the operations of the federal government? Because they have a duty to preserve their reserved powers. He says, the state legislators will be able to resist with more effect every assumption of power than any other power on earth can do. And the greatest opponent to a federal government admit the state legislators to be the sure guardians of the people's liberty. Your state and local governments are supposed to be the greatest opponents to the federal government, not their best friend, co-workers, and on the same payroll. It is their duty to limit the federal government's power to the few and defined so that we can have our liberty guarded. Look at what Jefferson says in 1812, already in 1812. The great object of my fear is the federal judiciary, that body like gravity ever acting with noiseless foot in unalarming advance, gaining ground step by step, and holding what it gains, is engulfing insidiously the special governments into the jaws of that which feeds them. He's talking about that precedent of the courts writing their own power and then compounding power upon power through precedent upon precedent until they engulf all. He says, then our government will become as venal and oppressive as the government from which we separated, because we will be functioning as an oligarchy of kings and queens and not as a constitutional republic. I just want to ask this question. Why should we have this faith in the Supreme Court to be the defenders of our liberty? How can we, given their history? This is the Supreme Court that said Dred Scott cannot be a citizen of the United States because he's a black man. Dred Scott, this was not the Constitution that declared Dred Scott to be property. It was the Supreme Court interpreting erroneously the Constitution, declaring Dred Scott to be property and not people. What about the Supreme Court that said, yes, it's okay to indefinitely detain Japanese Americans, men, women, and children because it's necessary for us to feel safe? Does this sound like a guardian of your liberty? No, it sounds like a guardian of federal power. And that's why they were never delegated this authority. Does the Supremacy Clause prohibit the states from their rightful remedy? Because your federal supremacist friend will say, well, the Supremacy Clause says that federal law trumps state law. Is that what it really says? How about we listen to Alexander Hamilton instead of a Supreme Court justice or a federal court judge? Hamilton says no legislative act contrary to the Constitution can be valid. That's exactly what the Supremacy Clause says, by the way. Let's look at it. The Supremacy Clause, Article 6, Section 2 of the Constitution declares, this Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. You see, the Constitution is the supreme law of the land. Nothing else has to happen. It is the Constitution, therefore it is supreme. However, the laws created by Congress, and may I also submit the regulations made by agencies, are only the supreme law of the land when they are made in pursuance to the Constitution. Not every law supreme? Only the ones that fit under the Constitution. You can't have federal laws and Constitution on equal footing, because then all it takes is one law that supersedes the Constitution. Then the Constitution's not supreme anymore. And if the Constitution is not supreme, from where does the Congress get their authority? Just themselves. Hamilton said, "No legislative act, therefore, contrary to the Constitution can be valid." You know what he's telling us? That if the federal government is creating laws that are not consistent with the Constitution, they are no law at all. What obligation do we have to find ourselves to be bound by a law that has no legal effect? The only obligation that rests up here, because there is no legal one, there is no constitutional one. Is the state's rightful remedy constitutional? Someone will try to tell you nullification is not in the Constitution. You can look for that word all day and you'll never find it. And therefore, nullification is unconstitutional. Well, let's look at the Constitution. The 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Let me ask you something. If nullification is not in the Constitution, what does that tell us? It's not a power that's delegated, right? And if it's not a power that's delegated, it's what? It is reserved to the states. So by not being in the Constitution establishes that nullification is a power reserved to the states. And it is their duty to do so. What does the Supreme Court say today about nullification? You all know this guy, right? Justice Roberts. You see, your federal supremacist friends won't talk about this opinion, and you won't see this in the media either. This is Justice Roberts' majority opinion in the first Affordable Care Act decision. I will read to you what he says. He says, quote, "We look to the states to defend their prerogatives by adopting the simple expedient of not yielding to federal blandishments when they do not want to embrace federal policies as their own." That is the Chief Justice of the Supreme Court of the United States in a majority opinion telling the states, you need to nullify. And then look what he says. This should eliminate every single doubt in our federal supremacist friends' minds. He says, the states are separate and independent sovereigns, and they have to act like it. What do you say? Isn't it about time we start acting like it? How can you dispute that? Is the state's rightful remedy lawful? Someone will try to say that the states can't nullify federal law. What if the states nullify federal law? I mean, how will we know what's lawful and what's not lawful? For the states to just refuse to comply with the federal law on whatever and however they choose. They don't like law, so they won't follow it. There'll be anarchy throughout the country. Nobody will know what's lawful and what's not. Here's the problem. What controls the federal government? The states. Why? Because nullification is not the states acting unlawfully. Nullification is the states enforcing the supreme law of the land when the federal government is acting unlawfully. States are not allowed to nullify, to disregard any federal law, but they have a duty to disregard federal laws that are not constitutionally established. We have to understand that the states have a duty to limit its creation. Because here's the consequence. If the federal government is not defined by the Constitution, then why do we have one? What is the purpose of the Constitution if the federal government can make whatever it wants? If the federal government is not limited in its power by the Constitution, then what is the limit of the federal government's power? The only limit to the federal government's power in a proper check and balance is when the states tell its creation, you can only do what we've delegated you to do, and anything beyond that is null and void and no law at all. So how do we start? What do we start doing? Nullifying. Well, look at remember what Jefferson said. When all government, domestic and foreign, and as little as great things shall be drawn into Washington as the center of all power, it will render powerless the checks provided of one government over another. Notice he didn't say one branch over the other, right? He said one government over the other. What is the government that's supposed to be checking over the other government? The states over the federal government. He even goes on to say, if the states, declaring the antecedent to that check being the states, if the states look with apathy on the silent descent of their government into the gulf which is to swallow all, we have only to weep over the human character formed uncontrollable by a rod of iron. Our states must take control. Because if our states refuse to take control, then our states are simply declaring that they are not states, they are colonies. And we are not free, we are subjects. Then I ask you, why do we have states? Why do we even need state government if that's how the way they're going to operate? They were created as independent sovereign governments. If they want to act like colonies, then why do we have them at all? If they're going to defend the Constitution, if they're going to defend our liberties, we need state and local legislation asserting the state-reserved power. We need state and local legislation denying unauthorized federal power. In the meantime, we need a sheriff, state, and local officials standing in defense of the rights and the liberties of the people and saying, until we have legislation, we will not comply. Because you have no authority over these matters. They are reserved, and your power is null and void. States have a rightful remedy. It is not an invention. It is not an interpretation. It's not a new idea. It was established by the nature of the Constitution being a contract. It remains because the states are still separate and independent sovereign. And it is their duty, because we created them, to protect our rights and liberties. And that's what we, the people, must strive for. Now, if you enjoyed this presentation, there's a book on the back table, Sovereign Duty. The lesson that I taught you comes from that book, Sovereign Duty. How many of you liked the slides and the quotes? Okay? This book teaches not just what I taught you tonight, teaches about the nature of the constitutional sheriff. It has a lesson on your right to keep and bear arms, your right to be secure in your property. It has a lesson on Article 5 conventions. It has a lesson on nullification specifically. And in this book, every quote and every document cited, I give you my original source in the back of the book. I give you all my research. Why? Because I believe that we have to stop believing people in what they say simply because they hold a microphone, stand on stage, they're on the news, or they call themselves professor or judge. We need to start questioning and finding the original source to all truth so that we can be the defenders of our liberties. You see, I don't want you to believe a word I told you. I want you to know it to be true. So I'm giving you all my research so you can test me out because I am confident in the conclusion. And if you test me, then you will be the expert. And then we will have a boldness to stand before our legislators, our sheriffs, and our local governments and say, you must defend our liberty, and we will not comply. Now here is our contact information. My husband told you about the radio show, the television show, but here's all of those things in case you need to write them down, KrisAnneHall.com. Now we're going to do a question and answer session, and it's not going to be very long, mind you, but we want to make sure that we have the opportunity to do questions and answers. But this is what I want us to know. There are rules to the question and answers, okay? Rule number 1, you must come up to the front and speak into the microphone. Rule number 2, do not take the microphone off the stand. Rule number 3, and I feel, which is more important than rule number 1 and rule number 2, you must have a question. And you must get to your question quickly. Because, I don't know, most of you know me. I'm a rather bold-spoken person. I'm not afraid to say, I'm sorry, where's your question? Okay? So if you want to debate me on an issue, I'm happy to do that after the class, after the question and answer session, or you can schedule a whole new event and we can debate, we can talk about your particular subject. So let's make sure that we get to the questions quickly, and so we can get as many questions answered as possible in this limited period of time. You must also afford me the latitude to say, I don't know. Because I don't know everything about everything. And the good news for you is I'm not running for office, so I don't need you to think I know everything about everything. Okay? So we will do, what do you say, John? 15 minutes, good? All right, we'll have 15 minutes of question and answer. And we need you to come up and line up at the microphones. This will be microphone A, this will be microphone B. If we get 2 lines,
page.
Lines formed, then we will go A, B, A, B, A, B. Sound agreeable to everybody? All right. Mr. Heston. I know who he is, so.
The question is, how can we be effective as local people of our county and of our state? How can we do this effectively as far as reaching our representatives? What do we do?
That's a very good question, and I'd like to answer it like I like to answer all of those, not through my opinion, but through the words of the men who created our constitutional republic. Samuel Adams said, "No people will tamely surrender their liberties nor be easily subdued when knowledge is diffused and virtue is preserved." He said, "But on the contrary, when the people become universally ignorant and debauched in their manners, they will sink underneath their own weight without the aid of foreign invaders." How do you become an effective champion for liberty, for rights, and for limited government? You must yourself first get educated. You must get educated so that you will notice when your rights are being usurped or transgressed. You must notice. You must get educated so that you can be righteously upset when that happens. And you must get educated so that you can educate your county commissioners, your city councilmen, your sheriff, your state government, and hopefully get educated so that you won't elect people that need further education. Okay? This is what we have to do. We must be jealous and vigilant of our rights, but we cannot do that if we don't know what they are. To finish Mr. Heston's question, I want to give the audience a popped quiz. Do not answer out loud, and do not cheat with your smartphone, your tablet, or your pocket constitution. Everybody agree to those terms? Don't even lip sync the answer, okay? There are 5 liberties in the First Amendment. To yourself, name all 5. Since we are here in Florida, we have a Supreme Court Justice named Fred Lewis who took a poll, found out that only 2% of the people polled could name all 5. But here's my question to you. If you do not know what your rights are, how do you know they're not already gone? Yes. And that's why education is always the first step. Yes, sir.
My name is Frank Powers. Do you think we should have a constitutional amendment that would limit the terms of federal judges, excluding the Supreme Court, or either have a reaffirming period like we do in Florida?
Okay, the question is, and I don't know, did everybody hear the question? Do we need term limits for judges, for Supreme Court judges, right?
Not the Supreme Court, but federal judges.
For federal judges. We have term limits for federal judges. It's called good behavior. Justices on the federal level do not have lifetime appointments. That's something that we need to change up here. They do not have lifetime appointment. They have appointment on good behavior. Do you know what that really means? That means we're supposed to be watching the behavior of our justices the way we monitor a kindergarten class. And the minute a judge behaves badly, he's supposed to be removed. There's no vote necessary. There's no time limit. I mean, seriously, if we identify a judge acting in bad behavior and he has a term limit of 12 years, do we have to wait 10 more years for him to go away? Well, that might be what happens, because everybody will be like, well, we don't want to impeach. We'll just wait until he's done. And then we'll have 10 years of guaranteed bad behavior. The problem does not exist in the limit of the judicial appointment. The problem exists in an impotent and useless Congress that refuses to engage in their necessary check and balance. How many of you listen to my radio show? On my radio show, I've been talking a lot about judicial abuse. Do you know we have Supreme Court justices right now that own hundreds of thousands of dollars in stock in companies that they regularly hear before them in the courtroom? Do you know their wives own stock in companies that they hear that are parties to the discussions in their courtrooms? You have Alina Kagan, the Supreme Court Justice, who was Solicitor General and created the argument in favor of the Affordable Care Act, sitting on the bench determining whether the Affordable Care Act is constitutional or not. That is a clear conflict of interest. You have Justice Ginsburg, who publicly came out against a state law and then didn't recuse herself when that state law came before the Supreme Court. Not only that, Justice Ginsburg sat before the entire world in an interview with an Egyptian reporter and said that Egypt should not use the U.S. Constitution as a model because it's not reputable. It was written by a bunch of racist, misogynistic men and could not be used as a model today. Our Supreme Court justices take an oath that they will support and defend the Constitution of the United States without hesitation or mental reservation. What Justice Ginsburg did was bad behavior. We have justices in the circuit court in Oregon that refused to allow defendants to read the First Amendment because she said the Constitution is not relevant in her courtroom. That is bad behavior. So we need to exercise the authorities that we have, and the only way that will happen is when we know what they are and demand that they happen. Yes, ma'am.
Are you aware of the Confederacy of the States, a movement that's been started?
I am not aware.
I don't think anybody else is. It's on the internet.
Mm-hmm. No,
it's a step towards what you were talking about.
Mm-hmm. Yeah, I can't speak on it. I'm not familiar with it.
Check it out.
Okay, yes, ma'am.
Hi, Jan Morrow. How do we apply your principle of state sovereignty to the issue of immigration?
That's a very good question, and we have to first identify what is the delegated authority of the federal government over immigration. The delegated authority of the federal government over immigration is that they are empowered to create Congress. Congress is empowered to create a uniform rule of naturalization. Period. The President's obligation is to faithfully execute the laws of the United States, meaning it is the President's obligation to faithfully execute the uniform rule of naturalization. Now, what kind of document is the Constitution? It is a compact. It is an agreement between the states. It's a contract between the states. And every state in the Union has agreed to the terms of that contract, which means every state in the Union has agreed that it is to the federal government to create the uniform rule of naturalization, which means that if an immigrant does not follow those rules or cannot comply with those laws, then that immigrant is illegal. That's right. And as a state, agreeing to the terms of the contract, the state has an obligation to abide by the terms of the contract. And that is why sanctuary cities are not lawful nullification. Sanctuary cities are nullifying a law that has been constitutionally created under proper delegated authority. Those states that harbor sanctuary cities are actually violating their contractual agreement. Now, because our immigration system has become muddied with the term refugee, we also have to address this as well. a uniform rule of naturalization. That's what immigration is supposed to be. However, refugee status is not a uniform rule, and it is not a pathway to naturalization. Therefore, refugee status is an unconstitutionally established delegation of a person's residency. That's why the states and the governors have the authority to refuse to accept refugees, because the power of refugee status is an undelegated authority, and therefore it is null and void. Not only do they have the authority to refuse refugees, but when the federal government is exercising power outside the Constitution, what do the states have? A duty to do so.
Yes.
Let me give you a little update. Right now, before the state of Texas is a Senate bill that will create an interstate compact that will secure our borders and reassert the state's authority to refuse refugees in their borders. Senate Bill 512 in Texas. Florida can sign into this interstate compact. This interstate compact is not superseding federal authority. It is not taking a power from the federal government. This interstate compact is ensuring that the state is in compliance with proper federal law. And that's one of the remedies that we can have, asserting our authority. You see, we have an obligation. If I can just add one more point. Do you know every state that offers in-state tuition to illegal aliens is violating federal law?
Florida offers that.
It is unlawful, according to federal law, according to the Uniform Rule of Naturalization. It is unlawful to hide, harbor, hire, or house an illegal alien, subject, depending on the terms, to up to 10 years in prison for every single violation. What does that say about our state legislators, who are knowingly and willfully violating a federal law that should subject them to 10 years in prison for each violation? And what does it say when we are prosecuting individuals for violating that crime, or for violating those laws, but we allow our representatives in government to violate those laws with no consequences?
Can I ask one more question? Mm-hmm. Okay, to tag along with my first question, and thank you for your answer. All right, we have the authority because we are in a compact, but how can Jacksonville, Gainesville, and Tampa be welcoming cities to Muslim refugees without the general public knowing about it? How can those city councils exert their authority, and what can we do to stop it? I understand what you're saying. You're absolutely right. We have to get educated. In the meantime, we are all at risk, and we need to be able to do the right thing right now. We need to be able to say, what is our path that we have to follow in order to get this under control?
Well, the first statement you said, they're doing this without our knowledge.
Most people don't know that.
Okay, so then that's the first step, the education. Remember, we are tamely suffering these lawless attacks on our liberty because we don't know. Let me ask you this question. How many of you think there are people in our state and local governments allowing these threats to come to America and to come into your communities, denying proper federal law, denying their responsibility and duty to protect our rights and our liberties? How many of you think there are people in state and local government who do that because they don't know any better? How many of you think that there are people in state and local government who are doing that because they have sacrificed principle at the altar of pragmatism? How many of you think there are people who are doing this because they're wicked, evil, greedy, and they want power and money out of it? So here's the question at the end of the day, what difference is the motivation? James Otis Jr., one of our founders who fought for our liberty, he says that I have come to despise those whose guilt, malice, or folly has made them my foes. Guilt, sacrificing principle on the altar of pragmatism. Yeah. Malice, greed, power, folly, ignorance. Once we get educated on what is happening, we have to become dedicated to the principles that will allow us to look at these county commissioners, look at these city councilmen, look at these state legislators, look at our governor and say, you are my foe regardless of your motivation. Which means you cannot continue to support them in their re-election regardless of the political party politics. That's why we're liberty first. Liberty over security, principle over party, and truth over personality. Because you see, government will do a lot of things when we're not looking. But they will never, ever do what we want them to do unless we make them do it. And if we continually reaffirm their guilt, malice, and folly through re-election, then we're actually giving them our consent and permission to be immoral and to destroy our liberties.
Hi, KrisAnne. Thank you for being here. What do you believe we should do about all the government corporation structure? And my second question would be about the oath of offices. In the Florida Constitution, in the statutes, there's two different oaths. And one of them pledges that it will support and defend the government. So, two questions. Thank you.
Part of being, and I will speak to you from a federal perspective, okay? Because each and every state is different. And then we will address the Florida issue just because I'm a Floridian and I understand how this works for you, which is different from for every other state. The powers delegated to the federal government are enumerated and defined. Yes. Within that power is not a power to regulate business within the states. What happens through federal grants, through federal regulations, the federal government is picking winners and losers, driving people out of business if they don't have the right lobbyists, and creating a system in which liberty and the rights of the people are sacrificed for their greed and political gain. Case on point, Monsanto. Okay? I don't know how many people are aware, but there are farmers who are growing heirloom crops. And the Monsanto seeds were blowing into their fields, corrupting their heirloom crops. The farmers tried to sue Monsanto to keep their crops, their seeds from corrupting their crops. The farmers did not prevail. And Monsanto filed a countersuit suing the farmers for patent infringement because their seeds were blowing onto the farmer's property and they were stealing patented property. What's even worse, is that Congress has created regulations that protect Monsanto from lawsuit, protect pharmaceutical companies from lawsuit, making them have immunity from lawsuit for their products. Once again, the problem is not corporations. The problem is the lawless activity of Congress. And when Congress unites with corporations, you are not a constitutional republic, you are a fascist society. The second question, in Florida, what powers are reserved to the states? Well, a power reserved to the states would be to regulate business. The problem is the creation of public-private associations. That's when you have the government funding private industry because they've deemed it to be a matter of public importance, like an airport. Your airports are privately owned. Your airlines are privately owned. They get profit, yet your tax dollars are used to build them. Do you see any profit from that? Now, the idea is the tax revenue pays that off. But when the government can partner up, then they're picking winners and losers again. And regulation of business doesn't stop any crime. It doesn't prevent any real harm from to the people either. Let me give you an example. We are missionaries to Haiti, okay? And one of our trips to Haiti, we stayed with a family in their home, and I love to bake, and so did the lady of the house. And in Haiti, they make these things called pâtés. The Spanish call them empanadas. Okay, so they're pastries stuffed with stuff and fried. So I was teaching my hostess how to make mango cream cheese pâté. Because they have lots of mango. We were making the stuff and frying it and put powdered sugar on it. They'd never had anything like that. They thought this was amazing. And she said this to me. She said, "Miss KrisAnne, Madame," she said, "let's go to the market and get a bunch of cream cheese, a bunch of mango, all the things that we need to make these things. We'll make a huge batch of them, and we'll go to the market and sell them. The Haitian people will love them. We will never be able to make enough to even last the whole day." And I went, huh. I said, you know, if I had that idea in America and I made up my mango cream cheese pâté and walked down to the street corner and tried to sell them, I would be arrested. Because in America, if I want to sell my mango cream cheese pâtés to the public, I must get a permit from the government to sell them publicly. Then I must also get a permit to make them in my home. Then I must pay the federal government for the privilege of them inspecting my home to make sure that I'm creating the mango pâtés in a way that is compliant with the government's rules. And then as I put up my stand and I sell my mango pâtés, I will have to put aside a portion of the sweat of my brow, the product of my labor, to pay the government for the privilege of selling what I have created. And she said, wow. She says, that's not the America I thought that was. Do you know what's interesting? In Haiti, if you have a cow and it produces too much milk that day, you just go to the street corner and sell it to your neighbors. There's nobody dying from mad cow disease in Haiti. They have these yearly festivals where the people have these big feasts, and you slaughter a cow, which is a huge thing there, right? Or a goat. And if your cow is too big for you, okay, your family can't consume the meat. You walk to the end of your street, you hang the hock of the cow off a tree limb, and as people come by, you hack off pieces and sell it. People are not dropping dead in Haiti from E. coli. You see, government regulation does not end disease or sickness. And just like laws don't stop crimes, regulations don't either. Do you know that for every legitimate regulation of a business, there is already a criminal statute that covers that behavior? We don't need to. What we need to do is enforce the law on people equally. Do you know why we created government regulations? Because business owners who were wealthy and powerful were not being prosecuted for their criminal negligence and the injuries and the deaths of their people. So we said, instead of enforcing the laws on these people, we'll regulate them instead. Has medical malpractice ended? Has corporate pollution ended? Has corporate abuse of employees ended? No, because laws don't stop crimes and neither do regulations. That's right. But what they do is make politicians and lobbyists fat. So to answer your question is once again back to education. How do you limit your government? You understand that you can't have liberty if you can't own your property. And if the government is regulating what you make, where you live, how you live, and the ideas that you have, then you are not free. That's right. On any level, state, local, or federal. And I think that answers the questions. Did I get them, Bob? No, what was the last one? This will be our last question today. What was the second question? Because I didn't get it. I forgot it.
No, KrisAnne, I was speaking more of the government corporations. State of Florida is a corporation.
Oh, I don't get into that sort of thing. That's outside my wheelhouse.
Okay.
Yeah, that's outside the text of in the federal Constitution.
All right. Thank you.
Mm-hmm.
The National Book Critics